Hello, I'm Nick Clarke. I'm the Senior Partner and Head of Dispute Resolution here at Aaron & Partners, and today I'm going to be answering some questions in relation to mediation and alternative dispute resolution. ADR means alternative dispute resolution, and broadly what that means is that it's any form of resolving your dispute that doesn't involve resorting to the courts. So mediation involves appointing an independent third party to help you resolve your dispute. The important thing about mediation is that that third party can't bind any of the parties to an outcome that they aren't happy with. It's a process of negotiation where hopefully at the end of it the parties enter into a binding settlement agreement, but unless they all agree there would be no decision at the end of a mediation. So mediation is an entirely voluntary process, and unless the parties agree, there will be no binding settlement. Arbitration is effectively a different form of court process. It's just conducted by a private arbitrator that you appoint and pay, but ultimately it's the same as a court in the sense that the arbitrator will make a decision, and that decision is binding on the parties even if they don't like it. I would say that mediation is suitable for pretty much anyone and any kind of dispute. The important thing is that you mediate at the right point in the dispute, because sometimes the arguments aren't sufficiently fully developed or the evidence hasn't sufficiently come out in order to allow the parties to have the certainty that they're making the right decision. So I think it's more a case of timing rather than whether it's suitable for any particular dispute. Nothing is legally binding unless and until you reduce it to a written settlement agreement that all the parties sign, and that's really important. In fact, anything that is said in a mediation can't be used outside the mediation unless and until you reach that point of agreement.